But this is an introduction to the California Legislature and its legislative process. This general overview is intended to acquaint those new to the state capitol with some basic information, particularly to appreciate some of the different aspects of the legislative process, as well as to get to know some of the players in that process. The website of the Office of Legislative Counsel provides valuable information on past and pending legislation. They have a wonderful glossary of terms and detailed explanation of the legislative process. There's also helpful guidance contained on the websites of the Assembly and Senate, as well as the governor. And be sure to check out the legislative process materials on the website of the Chief Clerk of the Assembly and the Secretary of the Senate. It's important to have a basic understanding of California's legislative process for those who operate in and around state government. This understanding begins with the concept of federalism, which is the sharing of power between the federal and state governments. The U.S. Constitution gives the federal government certain powers and reserves other powers to the states. Legal observers often describe the federal Constitution as a grant of power to Congress, and then in turn, state legislatures perform duties of the state government, similar to what Congress does for the federal government. The California Constitution has been described as a limitation on powers. In other words, this theory is that the legislature has all powers except those that are denied to it in Article 4 of the California Constitution. Now, turning to legislators, like many state legislatures, they have term limits, while members of Congress do not. State legislatures ratify amendments to the U.S. Constitution, and Congress generally may not require a state to enact or enforce a regulatory program, but they often encourage the states to cooperate, for example, by attaching conditions to the receipt of federal funding, such as when the federal government required states to make 21 the legal age for consumption of alcohol. They did so in exchange for receiving federal highway funding. The legislature, as its counterpart at the Congress, is bicameral, meaning it has two houses, with the Assembly, 80 members, and the Senate, 40 members. And these two houses, like Congress, meet in biennial or two-year sessions. Under the state constitution, legislators have to be at least 18 years of age and a U.S. citizen in order to serve in either house. Pursuant to the voters' adoption of Prop 28 in June of 2012, legislators may serve a lifetime maximum of 12 years in state office. They can serve all 12 years in a single house or in a combination of the two. The assembly members, again, 80 of them are elected every 2 years. The Senate, the 40 senators, are elected every 4 years. So half of the Senate is up for election every 2 years. Legislators have important staff members, both on their personal side and the committee side, and they assist members in performing the duties of their state office. The legislature in California is also served by professional staff at the Legislative Data Center, the Legislative Counsel Bureau, the Legislative Analyst, and the Bureau of State Audits, among others. Now, in California, we have essentially two paths to lawmaking. The initiative is the power reserved to the voters, the people of the state, to propose both statutes and amendments to the Constitution. This requires submission of a measure to the Attorney General for title and summary, collection and certification of signatures, placement on the ballot, and ultimately passage by the statewide electorate. Again, there are both statutory initiatives and constitutional initiatives. The other path for legislation is, of course, through the legislature and its legislative process, and they pass bills, and the governor acts upon those bills. Under the state constitution in Article 4, Section 8, it says that the legislature may make no law except by statute and may enact no statute except by bill. So the legislature considers bills to create statutes. And generally, that piece of legislation starts when a group, an individual, an organization, the legislator, their staff, have an idea for legislation. and a senator or an assembly member agrees to author that bill. The bill idea is then submitted to the attorneys at Legislative Council for drafting. They're the legislature's lawyers. And not only do they give verbal and written advice, but their main task is to draft legislation and all the amendments thereto. After the bill is drafted, it is introduced and printed, and no action for 30 days after introduction occurs. Upon introduction, a bill gets its first of 3 readings. Then the Rules Committee in each house assigns that bill to one or more policy committees for a hearing. Bills are assigned to these policy committees. There are 32 in the Assembly and 23 currently in the Senate. And they have different subject matter jurisdictions, from business and professions to the judiciary, education, transportation, and veterans, and many more in between. Also, between 75 and 80% of all bills are deemed to have some sort of fiscal impact. And that means the fiscal committee, which we call the appropriations committees in the Senate and Assembly, will also hold a hearing on those bills. The committee process includes, of course, receipt of the bill, a worksheet to be completed by the author's office, a hearing date being published in the Senate or Assembly daily files, the analysis being published of the bill, a hearing being held, and a vote taken on a bill. The votes are recorded and reported out to the full Assembly or Senate. At a bill hearing, the author presents his or her measure, followed by witnesses speaking for the bill and then against the bill. And then the author is allowed to make closing remarks. What can the committee do? They can make amendments. The author can submit amendments. The committee can make amendments to the bill. There's a vote on the bill, usually with the recommendation of the chair to do pass as amended, or a bill fails, in which case it may be granted reconsideration and gets one more vote. The bill can also be held in committee without a vote. Again, these actions are reported actually as a recommendation to the floor of the Assembly or the Senate. After passage from the Policy Committee as well as the Fiscal Committee, if that's necessary, then the floor process takes place. There are 2 additional readings of those 3 required. The second reading occurs when bills pass the committee, and they're read a second time in that House of Origin or the second House. And then they're moved on to third reading for final consideration. And that third reading occurs when the author is prepared to take the bill up for discussion and debate and ultimately a vote of the members on the floor. When third reading occurs in the second or other house, then a floor manager, sometimes referred to the old term of floor jockey, occurs, meaning that an assembly member presents a Senate bill on the assembly floor and a senator presents an assembly bill on the Senate floor. If the bill is approved in its house of origin, again, the bill is transmitted to the second house. If the bill is defeated, however, the member may seek one reconsideration and a second vote. Most bills require a majority vote in both houses, which of course is 21 votes in the 40-member Senate and 41 votes in the 80-member Assembly. However, there are some measures with a higher vote requirement, the most common of which is 2/3, which is 27 votes in the Senate and 54 votes in the Assembly. These are for urgency clause bills, some appropriations bills, constitutional amendments, and bills that may amend certain initiatives that allow amendment by the legislature, such as the Political Reform Act of 1974 or the Insurance Measure Prop 103. Now, if a bill or a measure is approved on the floor, then the House goes to the other house, sometimes referred to as the second house. And this process repeats itself, going through policy and/or fiscal committees as well. When a bill is approved by the second house, the original House of Origin must make a concurrence vote if the bill has been amended by the second house. Thereafter, the bill goes to the governor. For most of the year, the governor has just 12 days to act on a measure. And our governor has three options: to sign the bill, in which case it becomes a statute; to veto the bill and return the bill without his or her signature; or third, what we have is a pocket signature, which is allowing a bill to become law or a statute without the governor's signature. Now, that 12 days is extended to 30 days at the end of the legislative session, because at that time the governor has to consider hundreds, perhaps even as many as 1,000 bills that were approved by the two houses of the legislature during the final weeks of the legislative session. Thereafter, the Secretary of State, in coordination with the governor's office, assigns a chapter number to that bill, and most statutes become effective on January 1 of the following year. Although certain bills, including urgency bills and budget bills, along with three other types, take effect immediately, that is, upon the governor's signature. Now, keep in mind, in addition to the legislative process, that there's also lawmaking in the executive branch. That's because California's over 200 state agencies, departments, boards, commissions, and bureaus implement those statutes adopted by the legislature, and they are allowed to interpret, implement, and of course enforce those statutes. Now, these agencies and departments generally have rulemaking authority, which authorizes them to adopt regulations. Now, finally, legislators are also regulated in their official conduct. For example, they're prohibited from accepting honoraria, meaning they can't accept a payment for giving a speech, making an appearance, or writing an article. They're also bound by extensive conflict of interest laws, that they may not vote or introduce measures that would benefit them personally. In addition, legislators file an annual statement of economic interest, a Form 700, both when they assume office, leave office, and then annually while they're in office. There's also a revolving door restriction, which generally prohibits them from lobbying for compensation, the legislature, and other such rules. They are also prohibited from receiving payment from lobbyists, any sort of income, and they're limited in receiving gifts to $10 a month from a lobbyist or lobbying firm, or currently just over $600 annually from a lobbyist employer or other sources of gifts. So that again is a general overview of the California legislature and its legislative process.